I'm Alan Childress. I'm a law professor at Tulane and I teach the undergraduate course in notary law. My wife Michelle and I also teach at night on Zoom statewide a private course in notary prep. And I'm hoping that a little bit of the notary law that you learned today with a snippet will give you an indication of how we teach. We try to be as straightforward as possible and simplify something that is actually pretty difficult in the state study guide. I think you'll find the fundamentals book that's required for learning notary law and taking the exam is long and difficult. Some of it's difficult because law is difficult, but some of it's difficult because it was kind of organized over the years in pieces and put together kind of like Frankenstein's monster to the point where there's a lot of repetition and passages that don't fit with each other. Anyway, we can decode it as best we can. And some of the answers that you'll see on the state notary exam will be discussed today. All right, so this is the third in a series of reviewing notary prep books that are sold on Amazon, maybe sold elsewhere as well, that aren't great books. In fact, they're terrible books, but maybe we can learn something from them. Maybe we can learn some right answers from their wrong answers, and that's what I intend to do today. Of course, I'm trying to recommend books that are written by established educators who know what they're doing. And so one tip I have for you is to, anytime you see a book that you think you want to buy or you've heard you should buy, go to the Secretary of State's website where you can search for existing notaries, commissioned notaries. And you'll a lot of times find that the book on Amazon was not written by a Louisiana notary. So they can't possibly know all the differences and nuances of the civil law Louisiana notary that's different from any other state. It's what makes it special, which makes the exam hard, but it also makes notaries able to do a lot of things in Louisiana and make money on them that would be illegal for a notary to do in other states. So it's a big advantage to your career and your professional pride to be able to be more of a member of the legal profession and less a functionary as notaries are in other states. So search the name and see if they are in fact a notary, but then also look at the biography, the little bit of information that's provided. One book on Amazon is written by a Louisiana notary, and I haven't looked at the book and I'm not going to review it. But then if you look at her bio or click on the name, you find that she's been suspended from the practice of notary for over 20 years, meaning she's not eligible to do notary work and has not done notary work for 20 years. So whether or not her book is good or bad, she doesn't really have the kind of current status that I think I'd look for in an author. So other notaries that have written books, one, I don't think it's on Amazon, but one who does a course called Pass My Notary Boot Camp has only received her commission less than a year ago. So I'm not sure why she's considered to have an expertise. And it looks like it took her a very long time to pass the exam. So I wouldn't trust that. Plus, I think it's pretty unethical that she chose the name passmynotarybootcamp.com when for 12, 15 years, one established professor has always had passmynotary.com. So while I would recommend passmynotary.com, I would never recommend passmynotarybootcamp.com. And you can see from their bios or clicking on the link why that might be true. Another one who does a lot of YouTubes and is kind of seen a lot, only got her commission 3 or 4 years ago. And whether that's good or bad, I will just say, once again, maybe be very skeptical of some of the answers. And I'll review her app eventually, where I will expose that many wrong answers on it. And I think you should be concerned about relying on free exams with people who are teaching the wrong answers. And today I'm going to focus on a book that is full of wrong answers and is not written by a Louisiana notary. And in fact, I'm not even sure that the name David Harlow is a real name. A lot of these books on Amazon have such generic names, Roger Sullivan, Sophia Harper, and David Harlow, that you get the impression that it was written by AI and somebody slapped a name on it that they thought would be appealing to people because it was so generalized. But David Harlow, even though that's a common name, is not a Louisiana notary. A couple of books I would recommend, besides obviously going to some site and checking out whether they are an established educator. One is by my wife, Michelle, has written an outline where she, and I would get the 2025 one if at all possible, where she reduces the state study guide from 737 pages down to 190 pages and simplifies it and gives clearer examples. So it helps you really understand the book. One I wrote called The Side Piece has a lot of tips on taking the exam. And it's also in a 2025 edition, which is useful because it has in it an index that you can write into your state study guide, which will give you an index the day of the exam, because you can only use the state study guide the day of the exam is an open book exam. And but having an index means you can find the answers much more quickly than you otherwise could. And I really don't see how you can pass the exam without either creating your own very comprehensive index or copying the one that I've written in chapter 12 of this book. But it's got way more than an index. It's got a lot of lists that are very useful, keyed to the study guide with page numbers, a lot of tips on taking the exam, on registering for the exam, even some tips on how to practice afterwards. My wife, Michelle, and I also are starting to do in-person workshops for commission notaries on how to practice, how to write wills, how to write powers of attorneys. So you maybe aren't there yet, but I'm hoping in the long run that we will be your teachers. Another book that I wrote that's on Amazon is a series of sample questions and answers. And about half the book from this point on is explanations for them. So it tries to teach you the law in the process and not just tell you that you were right or wrong and maybe even give a page number. It really explains them. So those are books that I obviously would recommend, not to the detriment of other books that are real and written by real notaries, especially established notaries who aren't suspended. That would be good. So let me start with the one for today is David Harlow, who I don't think he exists. And as Rhonda says, it's probably a ghostwriter. I don't know what that means in this context, though. I mean, who is the actual writer? If it was actually a Louisiana notary, I would think they would claim that and put their bio all over it. One of the ways you can also tell that books are fake is when they claim things like, and many of them do, a 98% pass rate. Well, other states probably do have books that could provide a very high pass rate, if not 98%. There's no resource, including the ones that I'm pushing of my own, that would guarantee you or say that you will pass at a 98% rate. That's outrageous of a claim for an exam that has a 19, sometimes 17, sometimes 21% pass rate statewide. To say that any book would give you a 98% pass rate, you already know they're lying to you. And it also is a mystery how a book can say that when it was at the time it was published brand new. How does it have a 98% pass rate if it just was published 3 weeks before and could not have been used on an exam? If they're lying to you about that, maybe they're lying to you about the answers inside. Yeah, Marielle Henry says she's getting ready for the May 17th exam, as many of you are, and she's taking the McNeese University. I'm pretty sure that I actually taught your teacher at McNeese University. I think it was a law student, a really good law student of mine at Tulane. So, one way or the other, you're getting affected by me, whether you like it or not. All right, let's look at some of the actual questions and answers in this book, and I will teach you in the process some of the right things. There's a whole chapter on legal terminology and a lot of questions about legal terminology. Some of them are actually in the state study guide and therefore could be tested, but many of them are terms that are maybe used in common law states or maybe Louisiana lawyers know that are more about successions law and have or contracts law that wasn't covered deeply in the state study guide. But those terms aren't in the study guide, and they will not test you on things that aren't in the state study guide. When I say the state study guide, I'm always referring to fundamentals of Louisiana notarial law and practice. Everybody calls it the study guide because it originally was called that about 15 years ago. Ever since then, though, everybody calls it the study guide. So it's just it can't be true that they would test you on a bunch of the terminology that is talked about in this particular book. Let me look at some of the specific questions. It says that the Louisiana notary exam is divided into multiple sections: legal terminology, notarial acts and instruments, ethics and professional conduct, evidence and procedure. These are not the sections that the Louisiana notary exam is divided into. So I don't know where they're getting that from, because I don't think that's true of other states as well. Most of the times when these people are throwing stuff at you that sounds real, it's probably because it is real in another state, and they're just slapping the word Louisiana on the cover to try to get you to buy it. And it has nothing to do with the Louisiana notary exam, which is so different. And in this particular case, those sections that they say are on the exam are actually not on the exam. All right, let's look at some very specific questions. In a section that they call questions on general notary knowledge, I actually think you may well have a series of questions, if not a section, on general notarial knowledge, or the Office of the Notary Public, or basically chapters 1 through 7, mostly chapter 7 in the state study guide, could have several questions about how to become a notary, how to be disciplined or lose your commission as a notary, and some of the basic rules about signing and identifying people. One of the problems almost all of these Amazon books have is they concentrate almost entirely on chapter 7. They do not go into wills, donations, power of attorney, authentic acts that are the mainstay of Louisiana notarial practice, because they're not shared with other states, and a big part of the exam. So even if they were accurate in their answers, they're focusing on a small part of the exam. But I acknowledge that notary practice, or the office of the notary as a generic topic, is tested. So at least, some of it is what you do actually get tested on. But here's some of the ones they say. Which document is a Louisiana notary public not authorized to prepare? They say marriage license. Here are the choices: act of sale, marriage license, testament, judicial pleadings. Their answer, the one you're not allowed to do, is marriage license. And they're right. We're not involved with the creation of marriage license. In that sense, they're right. But they also then imply or say that judicial pleadings that you would file with the court or draft for a judge, that it's saying we are authorized to prepare. Well, no, it is very clear at the beginning of chapter 19 that pleadings are off limit to notaries, non-lawyer notaries in Louisiana. In fact, I think that's the heading in chapter 19, which is pleadings are off limit. So they're saying you can't do, as a notary, as much as we have power to do many things that only lawyers can do in other states, we can't draft judicial pleadings. And yet that's one of the options here, that they're saying you are authorized to prepare. It is true you're authorized to prepare act of sale and testaments, which is unique to Louisiana. But to say that you are also authorized to do judicial pleadings it's not only wrong, but I'm emphatically wrong, in the sense that the state study guide so emphasizes that that's where we draw the line at your being able to prepare documents or legal documents for people, is you can't prepare pleadings for people. They have a lot of questions that imply that your seal is the stamp that you use. I was trying to see if I have an example. The stamp or the crimper embossing tool, that's what they call the seal, because in other states, that's what they call the seal. So they have questions that they talk about the notary signature and seal, and they're talking about the signature and then separately this device. mechanical device. The reality is, though, and heavily tested on the notary exam, or frequently tested, I would say, is that your signature is your seal. What we define the seal to be in Louisiana is not a mechanical device, but your actual notary signature. And they frequently test on that, which is like a free point on the exam that you want to get. It's that square in the middle of the bingo card that you just have to go ahead and stamp because your signature is your seal, as Chapter 7 points out to you. This book, by separating those two, implies. Now, it's a good idea in practice to use your seal. To use a stamp or a rubber stamp or an embossing tool in addition to your signature as your seal. And that's because clients expect it or out-of-state documents might require it. But that's not the exam answer for purposes of Louisiana documents, where your signature is sufficient to seal it. The question number 10 they have, what does the seal of a notary public need to include? And then they go into things like social security number and the Louisiana state emblem. And, this would be an easy question if what they meant was your rubber stamp or something. But in fact, again, by mentioning the word seal, they're confusing the fact that the signature is your seal in Louisiana. Then they ask, this is one I just can't believe that they can get away with. 12, under Louisiana law, a notary public must renew their commission every year, every 2 years, every 5 years, or commissions are lifetime and do not need renewal. The real answer should be D, and you should know this, that commissions in Louisiana are lifetime and do not need renewal. They say the answer is every 5 years. I don't know where they're getting that from. We're the only state where notaries are commissioned for life. And since that's a real difference from other states, you can think they might test on it. Probably not, because it's too easy. Kind of everybody knows it. So you definitely would have answered here commission, and they say that's wrong. Commission over a lifetime, and that they say that's wrong. Every 5 years, I guess you do have to renew your bond or your errors and omissions policy as a substitute for the bond every 5 years. Okay, but that's not renewing your commission. And I will tell you one thing about the notary exam is they're very precise in the language and expect you to be. If they say commission, they don't mean bond, which is a sub part of getting and keeping your commission, but it isn't the commission. The commission is what any other state would call a license. We don't call that here because it's granted in a different way, and it isn't subject to licensure tax and all of that. So we don't call it a license, but you can think of it that way. And they mean the word commission here. If they said must renew their bond every 5 years, that would be correct. But that isn't what they say. That's just, I think, that's so basic that everybody knows that when they're thinking about becoming a notary. That it bothers me that this book is allowed to be sold, and somebody might study that and get it wrong on the exam. What is it? Number 14 is, what is an essential characteristic of matrimonial agreements, what you might call prenups, altering community property regimes in Louisiana? A, they can only be made with judicial approval. They can only be made with judicial approval after you're married, or with a few other exceptions. So that's not the worst answer, but you'd have to say after you're married for it to be correct. And one thing you want to do on the notary exam is take them literally. If they didn't say after you're married, then don't throw that in and overthink the question. B, they are irrevocable once signed by both spouses. Well, it's hard to believe that once you sign something, it's irrevocable in the state when you're choosing an arrangement between you and your spouse. It certainly is not irrevocable in the sense that you couldn't go to court to ask the court to change it. Courts do it all the time, especially in divorce proceedings, so it's not irrevocable. C, changes can be made at any time during the marriage without formality. No, you do have to go to courts, which is a big formality, and I don't even know, that answer is so ambiguous. What does it mean without formality? That you could just kind of shout it from your rooftop and then you've changed your prenup? Or formality is notarization? It's really poorly drafted. But what they say the answer is they must be acknowledged before a notary and two witnesses. Well, one way to do a prenup, if not going to court, is to do by the acknowledgement process. However, the reason this is not a great answer, and what I'm trying to teach you the law of, is that there are two ways to do a prenup before you're married that are valid in Louisiana. One is by acknowledgement, but the other is by authentic act. And by saying what's essential is that it must be acknowledged before a notary and two witnesses, not just it can be or one way to do it, but they say that must be. And it's just not even acknowledging that there's another way to do it, which is by authentic act. And probably the most common way that it's done is by authentic act. Though you won't be tested on kind of it's more done this way than that way. They'll always ask you what is the minimum that, or what is required or how must it be done. They will never ask you kind of what's the preferred way of doing it if there are two ways of doing it that are both valid. So this is just a wrong answer because they leave out authentic act. But what you learn from it is something that is tested, or is if you notarize, if you as a notary draft and then notarize a prenup, it won't be valid unless it's notarized either as an authentic act or as an acknowledged act by both spouses. That's a kind of an exam answer that they test on fairly frequently. 17. What is a distinctive feature of a predial servitude? Now, it can't be a totally non-Louisiana book if they're throwing around a word like predial servitude, which is a very Louisiana concept. However, they get it wrong. So I don't, there again, is it AI? Is it somebody who has a little kind of looks at a book in Louisiana law and pulls out words? They're not understanding it. The answer they say is correct, which is a correct statement. It is a burden on property, the servient estate, for the benefit of another property, the dominant estate. So I'll stop here and say that part is correct. And one thing you could learn from this book, or from me telling you about this book, is that predial servitudes are two properties that are related to each other, often next to each other, but they don't technically have to be. But one is a dominant estate, a piece of property, and the other is the servient estate. And the servient estate, even though it might be much larger, that's not what makes it dominant or servient, but the servient estate is burdened in some way. For example, it is one where you have to allow the person in the dominant estate to drive over a corner of your land to get to a road. That kind of rite of passage is a predial servitude. So it's a great example, and it's true that you could be tested on what is a predial servitude, and the definition they give, it's a burden on a property, the serving estate, for the benefit of another property, the dominant estate, is correct. The problem is their choice D. It says it can be established without the consent of the property owner. But that's also true, and they reject that because it can be established without the consent of the property owner. A conventional predial servitude is established by consent, an agreement between the two. Like if you guys decide to draw a property line this way and acknowledge that the fence is on his side of the property and the other side of the property is not where the fence is, that kind of predial servitude can easily be worked out conventionally, meaning by contract. And I could see them getting you to understand the difference between a conventional servitude that happens by consent versus a what would be called a legal servitude that happens because the law creates it. It's automatic. It doesn't require consent. So this answer is wrong. But let me go ahead and just teach you what might be one that's a legal servitude and not a conventional servitude. Well, the example I gave before is often a legal servitude. That the law is that if you are in an enclosed space and don't have access to a road, so you're landlocked, they say, not that you're surrounded by water, but you're surrounded by other properties. The other property that keeps you from getting to the road legally has to provide you access to the road. We want everybody to have land that accesses the road. So they have some minimal right to cross your property. They can't necessarily run through your front yard, but they have a legal right a legal servitude, a predial servitude arising out of law, and that gets them to that. All right. So that's just a bad answer to focus on one aspect and then ignore that the other aspect is true. 21. Which statement accurately reflects the treatment of matrimonial property under the legal regime of separation of powers, separation of property in Louisiana? Well, I didn't even read the answers. This is very confusing because a regime of separation of property in Louisiana is called a contractual regime. The legal regime is the community property regime. I know what they meant, a regime that law allows. And so they use the term legal regime as a descriptive thing. The problem is that's a term of art that you're expected to know that they often test on. Do you know the difference between a legal regime and a contractual regime? One arising out of law, the default rule of community property is called the legal regime, whereas one arising out of agreement, a separate property agreement, is called a contractual regime. Don't know why it's not called a conventional regime, because we used the word conventional to mean contractual with that servitude a minute ago. But the terminology that you need to learn for the exam is contractual regime is synonymous with separate property regime. And this question already obscures that. And 24 says, how are movable and immovable property distinguished in the context of Louisiana law? Once again, they give one answer that's correct, but they ignore that another answer they give is also correct. The answer they say that's correct, and I agree it is correct, movable property can be physically relocated, immovable property cannot. Yeah, that is a basic difference. But since they say how can it be distinguished and not as what is the fundamental or definitional difference, I would say D is also correct. Movable property, no, that's not right. C, immovable property is always subject to a mortgage. Movable property is not. That actually is accurate. And they ignore that as a correct statement as the difference, or at least the most tested difference between immovable and movable property. The answer that they're looking for on the exam is they often ask, which one of these is subject to a mortgage, or which one of these may you take out a mortgage to finance? And the answer is an immovable, such as a fixed trailer, which is fixed in the ground and become immovable, or land, or a condo, or a house. They're all immovables, and you can get a mortgage on them. But they may test you and ask, can you get a mortgage on a CD? Can you get a mortgage on a car? Can you get a mortgage on an expensive watch? You can take out a loan on them, but that loan is not called a mortgage in Louisiana. Rather, it is a UC9 security agreement that they talk about in a completely different chapter than chapter 18. But they do frequently test on, do you know that only immovables are subject to a mortgage? And this person doesn't seem to know that. I'll try to finish up by quickly saying they have questions on hearsay and evidence law. There's no mention of hearsay in your study guide, so they're not going to test on that. When they say, what is the legal requirement for a notary public in Louisiana while notarizing a document that involves a trust? They use the term trustor. We don't use the term trustor. We call him the settler. And if they use trustor on the exam, you wouldn't know the answer. You might be able to figure it out, but that isn't a Louisiana term, and it isn't mentioned in the trust chapter 25. So they're already using terminology that's non-standard, I guess is the nicest way to put it. And maybe I don't know, might be that there are other states that use the term trustor, or you could maybe call them a grantor, but they're called a settler. They talk about a series LLC in Louisiana. There's no mention in chapter 28 on business entities about a series LLC. So they won't test you on what is a series LLC. And I think the last example that they have, just most of the rest of the book has a lot of stuff that just isn't in the fundamentals book and therefore isn't on the exam. So I guess they just decided maybe it's on other states' exams, so they threw it in here. Things about evidence law, things about how court proceedings go. A whole section on ethics, which maybe we should have a section on ethics and test on it. I mean, there are some questions on conflicts of interest and notarizing for businesses that are mentioned in chapters 7 and 30 and can be tested. But there isn't a separate section on ethics as such. They say, for example, a notary public in Louisiana is offered a gift by a client in appreciation for notarizing documents. That they say the correct answer is you must decline the gift to maintain professional integrity and impartiality. That's not in the fundamentals, and I will just say in real life, you're allowed to be compensated for your notarial acts. Uh, you can't be bribed into falsely notarizing documents, but I think you know that, and that's not because of the payment; it's because of the it being a bribe to falsely notarize. So we as notaries set our own prices. We as no, that we as notaries can be compensated by that. We can make a living doing it. It's not something we have to give away free to anybody who asks for it. So if somebody comes, and I guess I violated this several times, because in my practice, occasionally somebody will come by a week later and say, I brought you some cookies because, that really worked, or that really helped us, or just thought that Michelle and I were nice while doing it. And I'll always take free cookies. So, um, I never thought that was even possibly an ethical violation any more than their payment at the time was an ethical violation. Uh, it's ridiculous. Anyway, it's just another example of how this book is not really written by a Louisiana person or focusing on what the Louisiana exam focuses on. And even when it does, it often gives wrong answers, like you renew your commission every 5 years, as opposed to it's a lifetime commission. Um, so that's what I wanted to do with that book, and get you to not buy it, but most of all, learn from it, learn from its mistakes. And I'm going to take a few minutes break and then come back on a different link that I hope some of you will join me again and review a little more quickly another book in the series. So I guess number 4 in the series will be reviewing this book that's been around a while on Amazon. And most of these other ones have just popped up in the last year or two, which makes me think they're AI. AI has gotten to the point where you can say, basically, write me a book on questions on Louisiana notary. And they do. And they're not good. Maybe that's how they were written. I don't know. This other book has been written by probably human beings, and I'll review it in a minute. So thanks for coming. I hope it was useful to you and that you learned something about the Louisiana notary exam, and not just don't buy this book, because that's my intent. But also don't buy this book. So I'll see you in a minute.